Hello. Welcome to Crime in Court. My name is Heather, and so first of all, I have a couple things to apologize for. So I apologize for my first try at this video because I recorded this and the second part already, and neither of them had volume because I was having some issues with my computer. I did a computer reset. I had to re-download Streamlabs on my computer, and when I did, all my settings were still intact except for my mic. That was the one setting that just decided, hey, I'm going to be different. So I recorded a bunch of pre-recorded videos, and I had to redo them all. So here is my second attempt at this. I apologize to anyone who came to the first one and could not hear me. This is part 1 of episode 16 in the Canton Cover-Up, Commonwealth versus Karen Reed, and what am I doing? All right, so this is the episode 16, the Commonwealth doubles down on their lies, part 1. And this is part 1 because we're going to go through the 300-page something document from the Commonwealth opposing the defendant's motion for sanctions and disqualification. So we're going to go through that filing. The first 25 pages is what we're going to go through today. I'm going to come back on screen. We're going to go through the first 25 pages. So the second thing I have to apologize about is I'm in the dark today. As you can see, I have a migraine. I woke up with a migraine at 4 a.m. I really didn't want to do any recording today, but actually I'm feeling a little bit better, and I really didn't want to make you guys wait any longer. So I'm here re-recording this episode. All right, so like I said, we're going to be reading through the Commonwealth's opposition to the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney. The first 25 pages is their argument, and so then we'll stop it there, and then the rest of it is all of their exhibits, and a lot of it we've seen already through other filings with especially Turtle Boy. If you've gone through the Turtle Boy charging documents with me, you've seen a lot of it, a lot of the exhibits, because they just repeat themselves a lot. So, excuse me. Sorry. So we will go through the exhibits another day, but we're going to go through the argument today. So without further ado, now comes the Commonwealth in the above captioned matter and submits the following in opposition of the defendant's claims that her indictments for second-degree unaliving in violation of GLC 2651 manslaughter while operating under the influence in violation of 13 and a half and leaving the scene of a personal injury / unaliving in violation of GL 9024 2A and a half. I just want to point out they have an A and a half. So if you have any reason to doubt the Commonwealth, they have a sanction or a statute that's an A and a half, by the way. So just, putting that out there. So they're saying that the Commonwealth is saying that they believe the dismissal. They believe that the Commonwealth's. The Commonwealth believes that the defendant's motion for the sanctions and disqualification should be dismissed because of a statement. No, that's not what they're saying at all. Back that up. Sorry, migraine. They're saying now comes the Commonwealth in the above captioned matter and submits the following in opposition to the defendant's claims that her indictments for her charges should be dismissed because of the statement made by Norfolk District Attorney Michael W. Morrissey approximately 6 months ago, and a purported delayed disclosure about an investigation being conducted by the U.S. Attorney's Office. The defendant's claims are misleading and disingenuous, as they are premised upon the defendant's misperceptions and actions knowingly made to deceive this court and undermine the integrity of the judicial systems. Baloney. You guys are undermining the integrity of the judicial system by what you're doing. But that's my opinion. All right, over the past 2 years, evidence sought by and presented to the Commonwealth has not shown any credible evidence that another individual is responsible for John O'Keefe's unaliving. What began as Attorney Yannetti representing to the Stoughton District Court in February 2022 that the defendant lacked any criminal intent in a motor vehicle accident has spiraled into a national conspiracy theory premised upon the defendant's variety of flawed, unfounded, and sensationalized claims. However, truth is not dictated by the loudest voice. Blah, blah, blah. All right, so Michael Morrissey's August 25th recorded statement. If you haven't seen it, I suggest you watch it. It is interesting, to say the least. All right, so in response to an extraordinary degree of relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd, 2023 rolling rally of nearly 100 people traveling to witnesses' homes and calling them unalivers on August 25th, 2023. So, never mind. District Attorney Morrissey released a recorded statement that cautioned against the improper and unlawful harassment of statements. So they're basically saying, because Turtle Boy and his turtle riders went on this rolling rally, they're harassing witnesses. So then that was, in response to that, that's why Michael Morrissey put out this statement, because your rolling rally was harassing the witnesses. So in exhibit, where are we at? There's so many parentheses here. All right, so District Attorney Morrissey's statement fell well within Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or the public interest. And, sir, I would like to add that I believe there is likelihood of substantial harm to an individual or to the public interest with you in charge, and with Trooper Proctor there and Brian Tully there and all the other corrupt people that happen to be a really loud car outside, or a plane or something. I think that was a plane. Anyways, yes. So, now I totally lost my train of thought because it was really loud. So because he, anyways, never mind. All right. So District Attorney Morrissey's statement fell within, and that's what I was saying. Oh my God. My brain, ADHD plus a migraine. I'm really not on my game today, guys. I apologize. Don't hate me, and don't unsubscribe. It's just a bad day. So anyways, this is, they're saying that it's, public interest and possibility of substantial harm that may come if they don't make this public statement. But I say that their authority, their being in charge alone, makes it a public interest and substantial harm. It's the same qualification. So that means that Turtle Boy should be free and clear from any charges, because he's just doing the public a service by, exposing these corrupt mother lovers. All right. Anyways, so statements. What is this saying? Statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. So those are statements that are allowed by the district attorney, I guess, during a litigation. So District Attorney Morrissey's statement was also an appropriate response under the Mass R Professional Conduct 3.6c to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Under Mass R Professional Conduct 3.6c, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So they're saying they can make statements as long as it's within the statute to mitigate whatever bad publicity they got, to interfere with that, to intercept the bad publicity and spin it their way. So District Attorney Morrissey narrowly tailored his statement towards the harassment of witnesses and included a synopsis of the Commonwealth's case and evidence consistent with what had been publicly filed and argued in the courtroom. Further, District Attorney Morrissey's statement was made in response to an August 22, 2023 ABC News broadcast where Attorney Jackson and Attorney Yannetti and the defendant sat down for an interview with ABC News' chief national correspondent, Matt Gutman. They give a link there. So during the 9-minute and 37-second segment, videos of the Free Karen Read protests were shown, photographs of witnesses displayed, and the defendant made numerous comments about the evidence and her relationships. When asked what the defense believes to have occurred, Attorney Jackson passionately asserted pieces of taillight evidence were planted after the fact, and that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical, and he was beaten to the point of unconsciousness. And that was Attorney Jackson. Jackson then commented about his impressions of the victim's injuries, including a claim that the victim had defensive wound bruises on the backs of his hands. All the things that Jackson is saying in this video is part of their defense strategy, so I don't think that it is, they're definitely not, it's not like defamatory or, I don't know, because it's part of their strategy, so it should be protected in some way. I don't know. If any lawyers watch this, or people with legal expertise know anything about that, let me know. All right, so Attorney Jackson continued on to ultimately declare without an indicia of proof and substantial, I think that's indica of proof, and substantial evidence to the contrary. This was a cover-up. John was unalived inside that house. His body was placed outside. The defendant's motion to disqualify and sanction the Norfolk District Attorney's Office conveniently misrepresents this court's July 31st, 2023 ruling that reprimanded only the defense team, in particular Attorney Jackson, for making unethical and inflammatory comments about the Commonwealth and witnesses that arguably crossed the line of permissibility under Rule 3.6. See Exhibit D, memorandum, blah, blah, blah. This court stated that Attorney Jackson's inflammatory statements about the Commonwealth and witnesses appear to have fueled much of the publicity in this case, and that defense counsel did not have carte blanche to speak with the public, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. So because you didn't like what they say, you want to limit what they say, what they're able to say. That's basically what they're doing there. So on July 31st, 2023, this court held at this time that there was not a substantial likelihood that defense counsel's statements would materially prejudice the proceedings and denied the Commonwealth's motion without prejudice. So the Commonwealth's motion was denied. The court saw that there was nothing prejudicial about the defense's statements. So I don't know how this helps the Commonwealth's theory or strategy here in this filing, but I think it only backs up the fact that the court or the Commonwealth is overreaching in their power. So contrary to that warning, the defendant and counsel have continued to get... What warning? They weren't given a warning. The warning of you trying to ask them to stop talking, yet the court denied your motion? Contrary to that warning, the defendant and counsel have continued to give numerous interviews with local and national media outlets where they have unfounded and inflammatory statements about witnesses' character and reputation, repeatedly described the Commonwealth and its investigators as corrupt, and on September 15th, 2023, Attorney Jackson made a comment to the media in response to District Attorney Morrissey's recorded statement where he seemingly attacked the intelligence. He attacked the intelligence of the brilliant-minded District Attorney Morrissey by stating, "So listen up, sir, and I'll speak slowly so you understand. Michael Morrissey, we ain't got no quit." He's just offended that he got called slow. And I don't disagree completely. All right, so the defendant's continued attempts to materially prejudice the judicial proceedings and to try the case in the media is unprecedented, further supported by the fact that on September 17th, 2023, the defendant traveled with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer to the victim's home in violation of her conditions of release, as well as other places of interest in Canton. So apparently, it was part of her release. She might not be able to go to 34 Fairview Road or something, but I do know that this particular instance that they're referring to was when they were with a news producer. They were traveling around different areas throughout that were relevant to this case. And she stayed in the car. Karen Reed stayed in the car and did not go out and walk the property or anything on 34 Fairview. So I don't know what their basis is. The attorneys can still go there. A woman from television can go there. So I don't know what their argument is here. Anyways. When balanced by the amount of public and prejudicial statements made by the defendant and her counsel, the suggestion that District Attorney Morrissey's statement from over 6 months ago threatens her right to a fair trial is untenable. See Massachusetts R. Professional Conduct 3.6, Comment 7. When prejudicial statements... My dog is being annoying. Sorry. She keeps hitting my thing where my laptop is. When prejudicial statements have been publicly made by others, responsive statements may have the salutary effect of lessening any resulting adverse impact on the adjudicative proceeding. Further, the defendant's motion is premised upon case law that governs the breadth of closing argument, a distinction the Commonwealth recognizes as a more stringent standard not applicable to a narrowly tailored statement made months prior to trial. And we'll get into some of the rebuttals. Well, not necessarily the rebuttals, but the original arguments that they're trying to shut down, but they're really not. They're not providing. They're not providing case law. They're not providing really any kind of reason why what the defense is doing is wrong. And you're going to see that they cite Turtle Boy's name, or Aiden Carney, Turtle Boy. He goes by on YouTube, if you're not familiar. He is, they cite his name about 365 times or something like that. So it's a lot. This is a case against disqualification for Karen Reed's case, but yet they cite Turtle Boy's name and everything. So that's why I put in the opening image, the graphic, that Ken Mello was saying it's all Turtle Boy's fault, mostly. So further, the defendant's motion is... I think I read that. The defendant's motion is premised upon case law that governs the breadth of closing argument. Yeah, okay. So disqualification of counsel or his office is not a measure to be taken lightly. In considering whether to disqualify counsel or the Norfolk District Attorney's Office, a judge must closely scrutinize the facts before him or her to determine whether a lawyer's continued participation as counsel taints the legal system. That's from Commonwealth versus Scanlon. Motions to disqualify require an intensely fact-specific inquiry, and a judge should hesitate to disqualify counsel unless absolutely necessary. See Slade and Ormsby. I would say corruption is absolutely necessary. Prosecutors conduct wholly devoid of any intentional egregious misconduct. What does that mean? That doesn't make you devoid of any egregious conduct because you are the Commonwealth. You're a prosecutor. Anyways, disqualification of entire district attorney's office due to conflict of one attorney from prior employment is not appropriate. Okay. Further dismissal as a sanction is very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious, and appropriate only when a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. So it should only be done at the very, very last, as the very last resort, basically, and the actions have to be intentional and egregious. And I think they have been. Dismissal and disqualification warranted when the federal officers working closely with prosecutors willfully interfered with defendant rights. So this is according to this Commonwealth versus Manning, I think. When the prosecutor willfully interfered with defendant right to counsel by engaging in calculated effort to induce defendant to abandon defense theory. So they're saying only when the officers were working with the prosecutor to willfully change the defendant's theory. I don't know why that's working closely with prosecutor. It's on there for emphasis. So the Commonwealth disputes any ethical violations or misconduct surrounding District Attorney Morrissey's recorded statement, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. The production of letters between the Norfolk District Attorney's Office and U.S. Attorney's Office and Department of Justice, as it pertains to a federal investigation related to circumstances surrounding this case, the Commonwealth has not been advised of the parameters or scope of the federal activity, and the U.S. Attorney's Office has essentially kept the Commonwealth in the dark about the specifics of its investigation. So the Commonwealth knows nothing. They've been trying to find out for some time. what anybody knows about the federal investigation, and they have not been able to get their heads wrapped around it. So, the majority of correspondence between the Commonwealth and the U.S. Attorney's Office has been discovery requests for all facts of an exculpatory nature and all statements of witnesses related to the Commonwealth versus Reed case that may exist to enable Commonwealth's compliance with discovery. So they're saying all the communications between us and the attorney's office have been basically just to let them know we need any kind of exculpatory evidence in nature because we need to hand it over to Karen Reed. That was their disguise. Their very, very thinly veiled disguise of why they were really reaching out to the U.S. Attorney's Office. So as detailed in the Commonwealth's correspondence with the U.S. Attorney's Office and Department of Justice, the Norfolk District Attorney initially raised questions about the impartiality of then acting U.S. Attorney Rachel Rollins and the unprecedented use of federal power to interfere with a state homicide investigation. Rachel Rollins resigned on May 19th. 2023 following an ethics investigation that she misused the power of her office. Acting U.S. Attorney Joshua Levy assumed her role and is pending confirmation from the United States Senate to become the U.S. Attorney for the District of Massachusetts. And in his role, he has been investigating the corruption in Massachusetts. So we're going to find out hopefully soon, if there's any kind of federal investigation information that gets dropped soon. I'm looking. I don't see any. We need answers, feds. Come on. We need all of this to end for Karen and Turtle Boy and the Canton 9 and all the other people that have gotten wrapped up in this innocently. All right, so the Rachel Rollins, they're saying she was corrupt or whatever, and now you can't look into us because she didn't like us, and yeah, she probably, gave bad information because she was biased. That's all from a letter. The Commonwealth has continually recognized its constitutional obligation to disclose exculpatory information to the defendant, which includes broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability, and all statements of witnesses. According to this Commonwealth versus Donahue, defendant entitled to new trial when Commonwealth failed to request material and exculpatory reports from Federal Bureau of Investigations. So they're saying we don't want this to have to go to, a whole new trial, call it a mistrial or whatever, because we didn't give them the evidence that they needed. It's happened. So they didn't want that to happen to them. So they're just saying, we just want to give her the information. That's all we wanted. The Commonwealth's obligations also extend to any evidence about a law enforcement officer's untruthful conduct or an adverse credibility determination. Prosecutors' duty to inquire. They're saying it's their duty to find out. So despite requests made by the Commonwealth on May 9th, 2023 and October 12th, 2023, it was only on January 16th, 2024, that an assistant U.S. attorney not familiar or involved with the investigation contacted both the Commonwealth and defense counsels Jackson and Yannetti to discuss the possibility of disclosing information in the possession of the Department of Justice pursuant to federal regulations. As of February 15th, 2024, the Commonwealth has not received any grand jury minutes, reports, exculpatory, inculpatory, or specific information about the investigation conducted by the U.S. Attorney's Office, although it has made repeated requests. See Exhibit January 18th email to the U.S. Attorney's Office detailing a joint request for discovery. On February 9th, 2024, the Commonwealth Attorney Jackson, Attorney Yannetti, and Attorney Little jointly participated in a conference call with the U.S. Attorney's Office. During the call, the U.S. Attorney's Office indicated that it may release information to counsel for both parties, subject to a stringent protective order, but offered no definitive answers or clear guidance on what materials exist, nor what will be produced pursuant to federal regulations. The Commonwealth and the defendant anticipate both parties receiving privileged and protected materials from the U.S. Attorney's Office within the next week. They were asked, we know, in the most recent hearing, both parties were asked to sign a non-dissemination order, or a gag order. So basically, it's possible that the feds have already released the information that they were going to release, but so far it has just been released to the Commonwealth and the defense team. But it may be coming in coming weeks, then we might start to learn more. So the Commonwealth has diligently investigated the defendant's unsubstantiated allegations of police and prosecutorial misconduct. I'd say they're pretty substantiated, but I don't know. I've only looked at this stuff for hours upon hours upon hours. Efforts to disprove the defendant's allegations have included interviewing additional witnesses, submitting evidence to a veterinary forensic laboratory that concluded that there was no canine DNA associated with the swabs taken from the victim's clothing in the area of the victim's injuries, so around his arm. But was he wearing his gray shirt at the time? Did he have it on? Was that because he had a gray long sleeve gray shirt, but it wasn't with him? So what happened to that? His belt wasn't with him. The voluntary submission of law enforcement officers' DNA profiles to conduct comparative analyses, extensive GPS analysis of the victim's phone, physical locations at various points, and the hiring of 2 independent forensic examiners, one of which is the senior digital intelligence expert from Cellbrite, to explain how the defendant's supposed expert misinterpreted the Cellbrite data from Jen McCabe's cell phone records, confirming that the internet search for how long to die in cold, the first one, and the second one, how long to die in colds, were definitively conducted at 6:23 and 6:24 a.m. when the defendant, Ms. Carrie Roberts, and Ms. McCabe were together on Fairview Road following the discovery of the victim's body. All of these measures were taken by the Commonwealth to acquire any exculpatory evidence and to safeguard and protect the integrity of the judicial system, not subvert it as the defendant has claimed. And that is such a slap in the face. They're so we're just trying to keep the peace. We're trying to do the right thing here. Baloney. If you were trying to do the right thing, you wouldn't be silencing somebody who's trying to out you for all your wrongs. All right, so the defendant also alleges that the Commonwealth improperly released information about the federal grand jury in November 23 to the media in response to a public records request. The Commonwealth denied a public records request as the federal rules of criminal procedure and federal case law dictate secrecy of grand jury proceedings. Records, orders, and subpoenas relating to grand jury proceedings must be kept under seal to the extent and as long as necessary to prevent the unauthorized disclosure of a matter occurring before a grand jury. We consistently have recognized that the proper functioning of our grand jury system depends upon the secrecy of grand jury proceedings. The secrecy is what's so unfair about it, and the fact that the defense can't provide any kind of evidence or witnesses. The requester appealed the Commonwealth's denial to the Supervisor of Public Records, which, at the command of the supervisor, required the Commonwealth to submit a supplemental response explaining why the letter was not public record. Hold on. They don't stop barking until I tell them to stop sometimes. So, the requester appealed the Commonwealth's denial to the Supervisor of the Public Records, which, at the command of the supervisor, required the Commonwealth to submit a supplemental response explaining why the letter was not a public record. See Exhibit N. The Commonwealth did not release any information or correspondence with the U.S. Attorney's Office until after this court vacated a protective order on January 23, 2024. All right. The defendant has failed to demonstrate any prejudice as the letters detail the Commonwealth's continuing attempts to obtain discovery. The letters were disclosed well in advance of trial. The materials are expected to be produced by the U.S. Attorney's Office forthwith, and contrary to representations made by the defendant, the letters pertain to a subject matter the defendant has vast and superior knowledge about. Attorney Alan Jackson, Attorney David Yannetti, and the defendant have knowingly engaged in conduct to undermine the integrity of the judicial proceedings, and the Commonwealth requests that this court revisit whether there should be an order as to prohibit extrajudicial statements to protect the right of a fair trial for all parties. The defendant's tactical decision to allege wrongdoings by the Commonwealth is conveniently premised on the defendant and counsel's own misconduct and ethical violations. It is now evident that there are numerous false statements made by defense counsel, including those contained within this motion for disqualification and previously filed defense motions, that were knowingly made to deceive this court and undermine the integrity of the judicial system. Where? How do you get to that? How do they get to that? I don't know. They're telling us that everything, or not everything, but they're saying that it's all false. It's all these lies in their motion to disqualification. Okay. All right. So one side's lying, not the other. That's which one is lying. That's what we have to find out. So following an investigation conducted by a special prosecutor, the Commonwealth has recently learned that for months the defendant, Attorney Alan Jackson, and Attorney David Yannetti have secretly conspired to perpetrate fraud upon the court through reckless mistruths, deceit, and hiding behind a social media blogger who has been criminally charged with intimidation of witnesses to direct and encourage the harassment of those witnesses. Yeah, he may have been charged, but he hasn't been convicted of those crimes yet because they're unconstitutional. In the defendant's motion to disqualify and sanction the Norfolk District Attorney's Office, the defendant attempts to disassociate herself from Mr. Aidan Carney, the man that she now calls an intimidator, who used his website TB Daily News, Turtle Boy Live, YouTube page, and associated social media accounts to perpetually intimidate and harass witnesses expected to testify as part of the Commonwealth's case against the defendant. Following an investigation conducted by a special prosecutor, Aidan Carney, Special Prosecutor Ken Mello, Aidan Carney was indicted by a Norfolk grand jury for 16 charges related to intimidation and harassment of witnesses in the case of Commonwealth versus Karen Reed. However, for months, the defendant and counsel have engaged in a concerted effort to use Mr. Carney as a literal bullhorn to say that they could not, and to say what they could not, and to disseminate information and opinions that counsel knows will have a substantial likelihood of materially prejudicing the proceedings. While the defendant struggles to use Mass R Professional Conduct 3.6a, not A and a half, but A, as a sword against the Commonwealth, the rules of professional conduct also apply to the defense counsel, including Attorney Jackson, who is not licensed to practice law in Massachusetts and is admitted under Pro Hoc Vice. Pro Hoc Vice applications must include acknowledgement that the attorney is subject to discipline by the Supreme Judicial Court and the Massachusetts Board of Bar Overseers, as demonstrated by the search warrants generated as part of the special prosecutor's investigation beginning on or around April 17, 2023. The defendant took deliberate action to start sharing defense theories, privileged materials, and evidence with Mr. Carney through an out-of-state intermediary. See Exhibit B. Search warrant, whatever. Brian Tully's seizure for their mobile devices, which was recent. To the next day, April 18th, 2023, Mr. Carney posted his first story in support of defendant entitled Canton Cover-Up 1, Corrupt State Trooper Helps Boston Cop Cover Up Unaliving of Fellow Officer, Frame Innocent Girlfriend. See Exhibit J. As of February 14th, 2024, the website Turtle Boy Daily News has 291 posts pertaining to the Commonwealth's case against Karen Read and an alleged cover-up of evidence in a series entitled Canton Cover-Up. You know what, buddy? I don't think you should, make more... this is written by Morrissey, so I'm talking directly to him. I don't think you should draw more attention to the fact that he has 291 posts about the corruption and cover-up that is going on in the town that you represent, or the county that you represent, I should say. I don't think you should draw attention to that because it's only making it appear like he's got much more to back his stance up, because he's written almost 300 times about it. I think he might be almost on 300 now as of today, but I'm not sure. All right, so anyways, where were we? In this article, Mr. Carney writes that none of this information has been made public and the Norfolk County DA's office hasn't sent a mountain of exculpatory evidence to Karen Read's defense attorney until recently, and further describes the impressions of defense counsel as shocked to discover evidence wrongly claimed to have been hidden from the defense. Okay. The defendant had instructed the intermediary to communicate with her through the Signal messaging application, explaining that it provides secure end-to-end encryption and instructed the intermediary to follow all information, which included witness information, home address, grand jury minutes, autopsy photos, and generally every piece of evidence that the Commonwealth provided to defense counsel onto Mr. Carney. So, okay, let's back up a track here. So they're saying this intermediary, she goes by the name of Natalie. That is her name. She apparently somehow inserted herself into this case, somehow got Karen to trust her enough to give her information and get to Turtle Boy, because for a little while this Natalie person was the intermediary between Karen and Turtle Boy before they ever even met, before they talked, before, when he first started working on this case. And eventually he started getting more and more information from Karen, fed to him from Natalie, supposedly. This is, I don't know how factual or what, I'm saying this is probably, what alleged to have happened. So anyways, Natalie, at some point in time, they were like friends in college, barely. And then at some point in time, Karen starts to question Natalie's honesty, integrity. I don't know, rightfully so, because Natalie at some point flips and starts feeding information to the Commonwealth and to the other side. And people that, witnesses in the case that are supposedly witnesses, I should say. They're more like suspects. Anyways, so Aiden was getting his information originally from Natalie. Eventually, at some point, Natalie dropped out of the equation and Karen was maybe giving Turtle Boy information directly as well. So that, but even if she was doing any of that, if they were doing this, that's not illegal. She wasn't submitting anything that was like private information. She wasn't doing anything illegal or submitting anything that was like under a gag. So let's get through this. This is a long document. My mouth's getting dry. All right, so the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting do not share, urgent, do not push, or do not publish anything from the report, and make it clear he, Mr. Carney, didn't just get it from us, but don't show the exhibits, just read them. Please tell him not to share the title. It has Yanetti's initials, referring to attorney David R. Yanetti. So all of those things were like, the directives that they're saying she gave him. Well, she's only saying like, okay, this isn't public yet. I'm giving it to you for your eyes only. Like she's only just giving the disclaimers of don't report this yet. It's not, don't put it on your show. There's nothing wrong with that. That's not necessarily, like starting a conspiracy to their, saying that the Commonwealth is corrupt. So when the defendant and her counsel took concerted efforts, to publicly distance themselves from Mr. Carney, beginning in the summer of 2023, the defendant and Mr. Carney would directly communicate on a regular basis. See Exhibits B. Okay, so maybe they exhibit or show or have some call logs or something. So call detailed records from Mr. Carney's phone revealed that the defendant's phone number and Mr. Carney had 189 phone calls between June and December 21st, 2023, communicating for an excess of 40 hours. See Exhibit B at pages 70 to 71. This was reported to be in addition to frequent text and phone communications made through the encrypted Signal application. So I guess with the Signal application, like your messages disappear or something, so they delete after a certain time. I don't know. I've never used it. Never needed to. Additionally, prior to publishing posts on his platforms, Mr. Carney would seek permission from the defendant or her counsel. Again, saying like he got permission, he got, this is all coming from Karen, whatever. Of note, on July 14th, 2023, the defendant filed a similar motion seeking the recusal of Presiding Justice Beverly Cannoni, where the unsubstantiated motion was premised on an affidavit submitted by Carney. I don't know what that has to do with that, but okay. So call detail records from Mr. Carney's phone also revealed that phone numbers associated with Attorney Yanetti and Attorney Jackson communicated with Mr. Carney at least 29 times between April 20th And May 2nd, 2023, Attorney Yannetti's phone number had 9 calls from Mr. Carney, and between April 20th through May 1st, 2023, Attorney Jackson's phone number had 3 calls with Mr. Carney. Oh well, so? It's not illegal. The Commonwealth has a good faith belief that these conversations continue even after Mr. Carney was criminally charged in October 2023 for the harassment of witnesses in this case. Okay. But what happens in the dark always comes to light. Yes, it does, Commonwealth, Mr. Morrissey. It will come to light. All corruption in your county. In the Commonwealth's motion to prohibit extrajudicial statements, the Commonwealth referenced a May 3rd, 2023 incident where, from the courthouse stairs immediately following a hearing in this case, Attorney Jackson encouraged those gathered outside, and in particular, sorry, dog's running downstairs. I'll just wait a second. All right. To contact witnesses and ask them inflammatory questions. In this video, Attorney Jackson asks, "Don't you want to ask some questions?" Then proceeds to point directly at Mr. Carney, saying, "I know you do," to which Mr. Carney enthusiastically responds, "I have been." The freedom of speech, mother lovers, they're totally allowed to say these words. They're allowed to ask questions of witnesses or suspects. It doesn't matter. They're allowed to ask questions, regardless of whatever label you want to call these people. They're not a special class of people. Anyways, so they give a link down in the footnote. When the Commonwealth referenced this incident in June 2023 as an example of an inflammatory extrajudicial statement, the defendants criticized the Commonwealth and called this an absurd characterization of what Attorney Jackson actually said. What? Oh, okay. Yeah. All right, so what the Commonwealth now knows is that it is not what Attorney Jackson said, but what he did not say, that is so troubling. Prior to making the directive, Attorney Jackson, Attorney Yannetti, and the defendant had all communicated with Mr. Carney and provided him non-public materials, theories of defense, and other pieces of evidence that enabled Mr. Carney to harass and intimidate witnesses. Okay, if you think so. What he has done is not harassment or intimidation of witnesses. He's asking people questions. He wants to know the truth. He's asking people to state the truth in their testimony, but yet he's in jail and not the liars and corrupt people who plant evidence at crime scenes. So those efforts were encouraged and celebrated by Attorney Jackson on the courthouse stairs, and immediately following Attorney Jackson, Attorney Yannetti, and the defendant hosted Mr. Carney for lunch at the Boston Seaport. Oh well, not illegal. A clear inference can be made that the defendant and her counsel directly encouraged and manipulated Mr. Carney to continue personal attacks on witnesses and their family members, including juvenile children. 17-year-olds that can unalive a man, I think, can take a little questioning about what they did, with the sole purpose to embarrass, intimidate, harass, and deter these individuals from testifying. No, sir, no. Prove that that was their purpose. That's not their purpose. You have to prove that. So Mr. Carney publicly stated that the motivation of his actions was to prevent this case from ever going to trial, conceivably a goal shared by the defendant. Nothing wrong with that. See Exhibits B and C for seizure of the defendant's mobile devices with accompanying affidavit and search warrant for location of defendant's mobile devices. Lawyers are subject to discipline when they violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another, as when they request or instruct an agent to do so on the lawyer's behalf. Paragraph A, however, does not prohibit a lawyer from advising a client concerning action that the client is legally entitled to take. Massachusetts R. Professional Conduct 3.3b, Comment 12. Preserving integrity of adjudicative process, lawyers have a special obligation to protect a tribunal against criminal and fraudulent conduct that undermines the integrity of the adjudicative process, such as bribing, intimidating, or otherwise unlawfully communicating with a witness. Paragraph B requires a lawyer to take reasonable remedial measures, including disclosure if necessary, whenever the lawyer knows that a person, including the lawyer's client, intends to engage, is engaging, or has engaged in criminal or fraudulent conduct relating to the proceeding. I think whatever that whole section that I just read could be put back and it could be immediately put into a filing just for them, from the defense to the Commonwealth, stating this, because they need to be reminded that they should not be helping criminals, their clients, get away with criminal activity, or witnesses, I should say. Yeah, I think that's a good reminder for them. So a practice of law premised upon providing non-public material, evidence, encouragement, and guidance to an individual who was actively harassing and intimidating witnesses far exceeds zealous advocacy, extends beyond the bounds of the law, and is contrary to the fundamental principles of justice. That's if what he was doing was, if you consider what Aiden was doing to be harassment, which I do not. Alright, so let me get through all these parentheses. Alright, so engaging in conduct that is prejudicial of the administrative justice. Oh, okay. Defense counsel may represent their client zealously within the bounds of the law, but they are to treat all persons involved in the legal process with consideration and to uphold the integrity and honor of the legal profession. Same to you, Mello and Morrissey and Lolly. Likewise, the defendant's claim that she has been materially prejudiced by the Commonwealth's deliberate misrepresentation and deliberate withholding of exculpatory information known to it about a federal investigation regarding its witnesses is highly disingenuous and utterly deceptive. See defense motion for sanctions. The evidence now shows that the defendant and her counsel have known about and shared detailed information about a federal grand jury investigation as early as April 13th, 2023, and publicly revealed the existence of a federal grand jury in court on May 3rd, 2023. The defendant and the defense counsel's knowledge about a federal investigation both predates and exceeds that of the Commonwealth. If the defendant's opposition to the Commonwealth's motion to prohibit prejudicial extrajudicial statements, the defendant writes, it had indeed been publicly reported that a federal grand jury had been impaneled. There is a marked difference between stating that something has been reported and revealing something that was previously unknown to anyone. This was not the defense revealing publicly that a federal grand jury has been impaneled, something about which the defense team would have no knowledge. Instead, as Attorney Jackson stated at the May 3rd, 2023 hearing, this was Ms. Reed's counsel reiterating what had been publicly reported. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. See Professional Conduct 3.3. All right, so prior to Attorney Jackson's statement, the existence of a federal grand jury had not been widely publicized and was, in fact, something the defendant and her counsel had utmost knowledge of. The only source of support the defendant's claim for the existence of a publicized federal grand jury was one footnote to TB Daily News, a post authored by Mr. Carney. See Exhibit G and K. All right, so sorry, I'm getting hot now. In this exhibit, or in this April 2023 post, Mr. Carney first announced to Turtle Boy Daily News, breaking news, according to reliable sources close to the matter, a federal grand jury has subpoenaed multiple witnesses who were in the house of Boston police officer Brian Albert on the night that fellow BPD officer John O'Keefe was unalived. The only individual who I can confirm with 100% certainty has received a subpoena in hand is Jennifer McCabe. So notably, call detail records produced in Carney's case reveal that Mr. Carney spoke with phone numbers associated with both Attorney Yannetti and Attorney Jackson on April 20th, 2023. A clear inference should be drawn that Attorney Yannetti and Attorney Jackson were the reliable sources that disclosed the existence of a federal grand jury. On April 23rd, 2023, through her intermediary, the defendant sent a follow-up to Mr. Carney, not public, so she sent it to Natalie first. The feds have been involved longer than anyone is likely guessing, and on April 28th, the defendant expressed frustration as to why Mr. Carney was not referencing the federal investigation more in his postings and offered additional information emphasizing that it's the U.S. Attorney's Office. They don't shoot and miss. They have a case and way more evidence than we do. I know this for a fact. Jen McCabe testifies this coming week. I'm not sure about the others. On April 29th, 2023, the defendant subsequently informed Mr. Carney that the DA's office has been informed. That is confirmed 1,000% that there was a federal investigation going on with them. On May 5th, 2023, Mr. Carney contacted the defendant about a rumor that FBI agents were in Canton. 2 days later, the defendant confirmed a communication with the U.S. Attorney's Office about the investigation responding to Mr. Carney. Not public, Levy confirmed no swarms of FBI were in Canton 2 days ago. All right. The defendant then boasts that acting U.S. Attorney Joshua Levy doesn't typically prosecute, like he never prosecutes. He just delegates to the assistants within the divisions, but he's running the grand jury. Mr. Carney openly discussed his knowledge that the defendant was interviewed by federal law enforcement and that the defendant and her counsel were working closely with the U.S. Attorney's Office. Communication, were they not supposed to? Is that wrong? Like, who cares that he openly discussed it? Communications authenticated by Mr. Carney and offered by his counsel in a January 8, 2024 hearing for the extension of an abuse prevention order sought by a former girlfriend of Mr. Carney also revealed that on November 28, 2023, Mr. Carney received information presumably from the defendant or counsel about the feds that I will not be making public, and details a phone call that occurred days prior between Attorney Yannetti and Attorney Jackson and Attorney Levy. See Exhibit O. The relevant extracted communication is attached to this motion. Upon request of the court, the Commonwealth will provide the entire extraction. Over 5,000 text messages contain highly personal and intimate details about Mr. Carney and a DV victim. If requested by the court, they should be produced under impoundment. Okay, well, she's only a DV victim if you want to consider that she's not total liar. So there's that. Anyways, it was disclosed to Mr. Carney that Levy requested a conference call with Yannetti and Jackson, where U.S. Attorney Levy requested the defendant delay the trial date, requested the defendant provide Verizon cell phone records that were ordered by this court on November 15th, 2023, and Levy asked them, if you are contacted by media in the next coming days or weeks, we would appreciate if you would not mention us working together. Why would he ask that unless he knew something was going to happen and they were contacted for comment on it? It appears the defendant is the sole source of information for the federal investigation surrounding this case, as the U.S. Attorney's Office never requested a police report, photograph, sworn grand jury testimony, a witness list, third-party record, or a piece of evidence from the Norfolk District Attorney's Office or investigations from the Massachusetts State Police. It is apparent from the statement attributed to the U.S. Attorney Levy that the information shared by the defendant that the U.S. Attorney's Office is working closely with the defense. Well, yeah, they must have gotten their information from the defense, all the discovery that they had. On January 18th, 2024, Attorney Yannetti falsely represented to this court that District Attorney Morrissey is well aware he's the target of a federal investigation as a result of his conduct in this case. That same day, the U.S. Attorney's Office took an extraordinary step to publicly rebuke Attorney Yannetti's representation by stating, we are aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity as a target of the investigation to anyone. Attorney Yannetti's dishonest, widely publicized representations were made with the sole intent of materially prejudicing the criminal proceedings. I doubt that. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of fact. Didn't they already cited this? As of February 14th, 2024, neither District Attorney Morrissey, his assistants, nor Massachusetts State Police troopers assigned to the Norfolk District Attorney's Office have been advised that they are the target of the federal investigation. The evidence, which includes numerous independent laboratories and experts not affiliated with the Commonwealth or the Massachusetts State Police, have not discovered a cover-up of evidence, police misconduct, nor a good faith suggestion. The evidence, which includes numerous independent laboratories. It doesn't matter about the independent laboratories. The people that were on the scene were planting evidence, planting taillight pieces up until days later. It's ridiculous. It's not necessarily that laboratory testing has anything to do with anything. It's that the investigation itself, the crime scene itself, was contaminated. So the right to present third-party culprit defense, not absolute. Latitude to raise third-party culprit defense, not unbounded due to risk of unfair prejudice to the Commonwealth. Defendant must offer relevant evidence of substantial probative value that does not confuse jury nor is too speculative. I think we have enough information to know that there is definitely a third-party culprit involved, a third-party culprit defense that can be used here. Under the guise of pursuing a third-party culprit defense, it appears that Attorney Yannetti distorted information and shared those mistruths with Mr. Carney to publicize a false narrative that Colin Albert, a juvenile, on January 29, 2022, and an individual not present when the defendant and victim arrived at the 34 Fairview Road as the individual who committed the unaliving of John O'Keefe. As Attorney Yannetti is well aware, this opinion is contrary to the evidence and likely shared with Mr. Carney as a the rules of professional conduct would expressly prohibit Attorney Yannetti from making such a baseless, prejudicial allegation. Okay, I'm sure Yannetti wouldn't face ruining his career for a woman who may or may not be falsely accused of a crime. You know, he's not going to just like chance his career on something like that. He has basis for the things that he said, and things can be interpreted in multiple ways sometimes, and that's how these court filings go. Someone says one thing and one person interprets it one way and somebody interprets it another way, and that's how you get a lawsuit or, you know, somebody going to jail. So it's totally acceptable that Yannetti can, you know, hear one thing from the feds and say that that's what he heard. And that's, you know, not necessarily a false narrative that he's spreading, but the Commonwealth is having you think that Yannetti and Jackson and Carney and Reed are all liars. This is so annoying, these people. All right, so extrajudicial. Did I read that? As Attorney Yannetti is well aware, this opinion is contrary to the evidence of the rules. Yeah, professional conduct. See this? Okay, so extrajudicial statements regarding the character, credibility, reputation, or identity of a witness, opinions as to the guilt or innocence of the defendant, the performance or results of forensic testing, and information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial, are subjects likely to have a material and prejudicial effect on criminal proceedings. In February 2022, Stephen Scanlon, a private investigator, contacted and met with Attorney Yannetti. Mr. Scanlon indicated he knew Brian Albert and was interested in helping the defense, but did not have personal knowledge about the case, nor did he speak to any witnesses or have insider knowledge. When Attorney Yannetti inquired of him about 17-year-old Colin Albert and an ATF agent who was at 34 Fairview Road, that'd be Brian Higgins, Mr. Scanlon denied knowing either party or details about their association to this case. Mr. Scanlon did not conduct any investigation for Attorney Yannetti, and it appears their relationship terminated in February 2022. 16 months later, in June 2023, Mr. Scanlon received a phone call from Mr. Carney that was surreptitiously recorded. And I'm going to read this. So I think they want to get... It says that they don't have jurisdiction to get Carney for wiretapping because he secretly recorded a phone conversation. So Mr. Scanlon suspected that Attorney Yannetti provided his information to Mr. Carney. During this unlawfully recorded conversation, which was published briefly on Turtle Boy Daily News, Mr. Carney pressured Mr. Scanlon to adopt assertions that he had personal knowledge Colin Albert was involved in, and to state that he knew John O'Keefe was his life was ended inside that house. Both statements were categorically denied by Mr. Scanlon on this call and are contrary to the evidence. The Commonwealth has reviewed this recording and provided a copy to the defendant. Okay. Approximately 3 months after that call, on September 6th, 2023, Mr. Carney posted a story that deceptively mischaracterized Mr. Scanlon's statements and falsely represented Mr. Scanlon as a whistleblower to scapegoat Mr. Scanlon as the supposed tipster that should buttress the defendant's unfounded theory that Colin Albert was involved. And that's, see this Canton Cover-Up Part 133. Mr. Scanlon has expressed frustration that lies were being spread about him and his involvement in this case, calling the situation bullshit as the defense has dragged him into a case that he is not involved in nor has personal knowledge about. according to the Commonwealth. All right. So further in this September 6th, 2023 post, Mr. Carney writes, our sources at Moakley Courthouse tell us that Steve Scanlon has been subpoenaed and testified in front of a grand jury specifically about his contact with Brian Albert and his knowledge of what happened inside 34 Fairview Road. An inference can be made that this source was the defendant or her counsel, as the first contact the Massachusetts State Police had with Mr. Scanlon was on September 8th. 2023. Contrary to the defendant's representations, the Norfolk District Attorney's Office has no bias or prejudice towards the defendant or personal stake in the outcome of this prosecution. Sure. As in any criminal prosecution, the Norfolk District Attorney's Office is motivated by what the evidence has shown and the interests of truth and justice. Sure. I do not believe you for some reason. Conclusion. In conclusion, the defendant's motion for disqualification and sanctions should be denied. The defendant has failed to show any prejudice, nor has the evidence in good faith shown that the Commonwealth has engaged in prosecutorial misconduct. Presumptive prejudice warrants dismissal to prevent repetition of misconduct. Moreover, where a trial date is imminent, the Commonwealth takes the opportunity to renew its request that this court impose an order that restricts any extrajudicial statements and extrajudicial dissemination of evidence until a verdict is returned. So they're basically asking the court again to put in some kind of some kind of gag order on all the evidence and extrajudicial statements and extrajudicial anythings, which make it incredibly hard for a defendant to defend themselves in the public eye. And they are allowed to do that by, their amendment rights. Anyway, so we'll get into that in the next part 2 of the Commonwealth doubles down on their lies. We're going to get into some of the rebuttal of this in the defenses. They actually put in the defense's motion in the exhibits. So we'll see. It was filed under seal, but they filed it not under seal, so we have it. All right, so during a September 15th, 2023 hearing, defense counsel acknowledged that national publicity will only intensify as the trial dates approach, where, as stated by Attorney Yannetti, in his opinion, he boasted that the defendant is the most infamous criminal defendant in America. Further, immediately following this court setting a trial date on September 15th, 2023, Attorney Jackson stated to the media, I can guarantee you that Karen Reed and her family will never ever quit, not until the last truth comes out, not until John O'Keefe's unalivers are brought to justice. The danger of publicity surrounding pretrial hearings is particularly acute because it may be difficult to measure with any degree of certainty the effects of such publicity on the fairness of the trial, and unrestrained extrajudicial statements could influence public opinion and inform potential jurors. But anything that the Commonwealth says, anything that is released from the Commonwealth to the media also taints the public perception. So it goes both ways. It's not just one way. You can't talk about it either then. Unprecedented public interest and media coverage warranted court order requiring counsel to comply. All right, that was in whatever case they were citing there. So furthermore, the defendant has previously scoffed at the Commonwealth's absurd efforts, I would say that they are absurd, to preserve her rights for a fair trial, and claimed that the Commonwealth seemed to be arguing that it knows better than Ms. Reed's legal team how to best preserve her right to a fair trial. And I agree, the Commonwealth has no bearings in defending the client, the defendant. The defendant is hiring defense counsel for that particular reason, to zealously represent her. And Commonwealth is, their sole purpose is to prosecute her. So, yeah, I don't know. They have no, their strategy shouldn't cross paths. So the Commonwealth does not claim it knows better than the defense. However, based on the full picture of the representation presented before this court, the Commonwealth has genuine concern about possible post-conviction claims premised on a defendant's claim that Attorney Yannetti and or Attorney Jackson were ineffective. Oh, that's it. They're protecting Karen Reed by making sure that she doesn't come back and say, oh, Yannetti and Jackson were ineffective. Ineffective assistance of counsel, basically. So they're just trying to preserve that. They're just being so helpful to Karen. Therefore, the Commonwealth respectfully requests this court engage the defendant in a thorough colloquy about her rights to effective representation, and should the defendant wish to proceed with Attorney Yannetti or Attorney Jackson, a clear finding that the defendant waives any legal claims challenging the assistance of her counsel. So they want Karen Reed to waive her claims to any effective assistance of counsel for the future by having some kind of conversation. They want the court to have some kind of conversation with her about the pros and cons of keeping Alan Jackson and David Yannetti on as their attorneys, as her attorneys, and if she still wants them, if she still wants to go forward with them, then she needs to waive her claims to assistance of her counsel. Bullshit, man. That is bullshit. Get out of here, Adam Lawley and Michael Morrissey, and you too, Laura McLaughlin. Get out of here. That's ridiculous. You guys need to stop with the doubling down on your lies and just come clean, man. Just start to come clean with all your corruption. We're getting old. It's getting real old listening to all your lies. So we're going to stop here, and we'll start going through the exhibits in our next part. We won't read it all word for word, but we'll read some sections. There's a lot that we still haven't seen because there have been a lot of motions that have been done, in and back and forth that we haven't necessarily seen recently that have come up. So they might be in here. All right. So thank you so much for joining me for this. I'm sorry I feel under the weather, and I'm really just not, my brain's not with it. So you probably can tell my energy is really low. So I apologize. I hope that you still at least got something out of this video with the content and the reading of the filing. Yeah, I think I said everything I wanted to say. As I said before, the motion from the defense to disqualify them and for these sanctions was filed under seal, but it's actually in the exhibit, so we'll get to read through that, and it is interesting reading. So we'll get through it, and it might be a couple more parts, but we'll see. So again, thank you so much for watching me, and have a great day. Thanks again. Bye.